Go back to prison. I did 4 years in prison. Plan on ever going back to prison.
Because when they listen to jail calls, you aren't helping.
He walked into that courtroom with a simple explanation. His brother had the gun. Not him. He was just in the car. And for a moment, it almost sounded reasonable. But the judge had already seen the full picture. 4 charges across 2 states, a parole hold from Montgomery County, and a corrections officer who left that prison with blood in his mouth. The question was never really about the gun. The question was whether the court was going to believe a story that the record had already told differently. To understand why this case matters, you have to go back further than that courtroom. Leandre Ward was 26 years old when he stood before that judge. 26. And already, his legal history stretched across Ohio and Alabama like a roadmap of compounding consequences.
Robberies in Baldwin County has been arrested in Ohio. We told you last week the Baldwin County Sheriff's Office was looking for this man, Leandre Ward. Well, tonight Ward is sitting in jail in Dayton, Ohio. Deputies there say Ward shot a man several times during a drug deal. After that, deputies say he led them on.
He had served prison time in Ohio, run his sentences concurrent, and walked out on parole in both states simultaneously. For anyone unfamiliar with concurrent sentencing, that means both sentences run at the same time rather than back to back. A break that courts do not hand out routinely. Ward had received that consideration. He had been given a path, and yet here he was, standing in an Ohio courtroom, facing revocation of his community control, with an Alabama parole holder waiting on the other side of whatever the judge decided today.
And on January 29, 2029, you were convicted of a illegal possession of a firearm in Clark County, Alabama. This could result in revocation of your community control, imposition of the sentence that was reserved. Would you like to have legal counsel?
Community control is the legal term for what most people know as supervised probation. It is not freedom. It comes with conditions, reporting requirements, and the constant understanding that any violation can activate the sentence that was held in reserve at the original hearing. In Ward's case, that reserved sentence was 18 months, not the full 36 months the charge carried. The judge had shown restraint the first time.
The gun charge was a felony, but the obstruction as well as the 2 traffic were misdemeanors.
Okay, what was the felony?
It was a certain person's forbidden to possess a firearm.
The question now was whether that restraint had been earned or wasted. The prosecutor, Teresa Hyatt, did not come to that hearing unprepared. She had spoken directly with the original case attorney, who had handled this matter from the beginning and whose position had never changed. Ward should have gone to prison the first time.
Like the defense attorney stated, there was some confusion. Alabama does their sentencing a little bit different. Regardless of those sentences, Mr. Ward has a parole holder through Montgomery County, and they have stated that he will be facing a parole violation and will likely be going back to prison on that, as well as due to the violations and his behavior while in community control, I do not believe that he's a fit for community control.
He had been in custody on a violent felony, an aggravated robbery case, when he assaulted a corrections officer inside the facility. Let that land for a second. He was already incarcerated, already under supervision, already facing serious charges, and he still struck an officer multiple times in the mouth.
Your Honor, I actually spoke to Ms. Nicholson because it was her case. She indicated that during the pendency of this case, this defendant wound up having 3 different attorneys. He was in prison already for a violent offense, which was a felony 1 aggravated robbery case, when he assaulted the corrections officer in this particular case. And her position from the beginning was that he should go to prison on this. The fact that he has a parole violation in Montgomery County, I mean, I agree that that's great that they're going to send him back to prison on that. But he only has 96 days on a possible 36-month sentence. And quite frankly, I just feel like if he's going to go to prison, then he should do some time for assaulting a corrections officer while he was in prison the last time.
That detail matters more than it might seem on the surface. An assault on a corrections officer is not treated the same as a standard assault under most state statutes. It carries elevated charges precisely because officers operating inside a facility are in a uniquely vulnerable professional position. They cannot simply walk away, they cannot escalate force without institutional consequence, and they depend on the behavioral compliance of the population they supervise. When Ward struck that officer, he was not just breaking a rule. He was targeting someone who had no clean exit from the confrontation. And this is where Ward's own explanation begins to fall apart in real time. He told the court the other charges were just traffic violations, misdemeanors, things that happen. He told the court the firearm charge was not really a possession charge, that he was simply in the car with his older brother, a man he had not seen in 6 years, who happened to be a registered gun owner with a weapon Ward claims he knew nothing about. He argued that the Alabama Parole Board itself proved his innocence by not sending him back on the firearm charge, and for a moment it almost held together. Almost. But the record said something different. The gun charge had been filed as a felony, specifically, certain persons forbidden to possess a firearm, a charge that applies to individuals with prior felony convictions regardless of whether the firearm was on their person or simply within their proximity and control. Ward's brother being a registered owner was legally irrelevant to Ward's status as a prohibited person. The law does not create an exception for family members. It does not bend for good intentions, and Ward's explanation, however sincere it may have sounded, did not address the one fact that the charge was built on. Here is where this case connects to something every person watching this has experienced. You have been in a situation where the rules applied to you and not to someone else. A workplace where the manager's friend skated past consequences that would have ended your career. A neighborhood where outcomes depended on who you knew rather than what you did. Ward was trying to use that same logic in reverse, arguing that because the system had once shown him mercy, it was proof of his innocence rather than proof of leniency. That is a fundamental misreading of how legal mercy works. Mercy is not exoneration. It is a choice the system makes to give you another chance. The defense attorney, to his credit, has made the only argument available to him honestly.
Okay, thank you. Mr. Engel?
Your Honor, he's indicated to me he's been locked up since August 9th of last year. I know he's got a bunch of days on this case and not a lot left on this case. What I would recommend to the court and hope the court would accept is that the court just give him credit for the days that he served on this case, unsuccessfully terminate him from community control here, and let the adult parole authority do whatever it's going to do.
Ward had been locked up since August 9th of the previous year. He had credit for time served. His community control period was nearly finished anyway, projected to end by late June. The attorney asked the court simply to close the case, apply the credit, and let the parole authority in Alabama handle whatever came next. It was a practical argument.
How much time does he have on this charge?
He has 96 days. which
96
I've got
days,
credit for.
okay. And he was charged with, do you know, Ms. Hyatt, what the injuries were to the officer?
Oh, I can find that out, Judge. And I'm sorry, you did reserve 18 months, because this is a 22 case, just so you know. It was not the full 36 months. You reserved 18.
It was also the argument of someone who understood that the facts did not leave much room for anything else. The judge was not moved by the timeline. What the judge said next became the most important sentence in that courtroom. After listening to Ward explain his brother, explain Alabama, explain Ohio, explain the concurrent sentences and the parole holds and the traffic violations. After all of it, the judge looked at a 26-year-old man and said simply, "You are much better than this."
I just want to apologize to the court, apologize to probation.
How old are you?
I'm 26.
Okay. Why do you think you're having such a hard time in life?
I don't really.
Maybe it just sounds like it. You've got 4 different charges in Alabama. Were those separate charges?
Yes, Your Honor.
You served prison time here. You're 26 years old. You struck an officer while you were in prison. Why do you think that is?
You are really more capable. And then revoked his community control and imposed the 18 months.
We have to change course. So I'm going to revoke your ILC. Start doing what you need to do. Then you're going to do your 18 months. You're much better than this.
Really?
More capable. You keep going back into old habits. Those have to go.
Here is the question worth sitting with when someone has been given multiple second chances across multiple states and still ends up in the same chair. Is the system failing them, or are they failing themselves? There is no clean answer. And that is exactly why this case will not leave you easily. The sentence was delivered. The 18 months were imposed. But the Alabama parole hold still waited. Ward would serve his Ohio time and then face Alabama's reckoning on the other side. The corrections officer who bled in that prison never appeared in that courtroom. No one writ his name into the record. He was a fact in a file, a set of photographs that may or may not have been submitted, a cut on the inside of a lip that the defense described as basically a misdemeanor.
Actually, to be honest, Your Honor, it's not like blood gushing from his mouth. There appeared to be a cut on the inside of his lip.
So it was basically a misdemeanor assault other than the fact that he's a corrections officer.
There was no serious physical harm,
Okay.
Your Honor, yes, because this was never a felonious assault case.
Okay.
That
Anything else
officer's
you want?
experience of justice, whatever it looked like, happened somewhere outside that hearing entirely. What this case teaches is something the legal system reveals quietly and consistently. Accountability does not always arrive in full, and mercy is only meaningful when it is met with change. The judge saw a young man with capacity and watched him repeatedly choose otherwise. The gavel fell not out of cruelty but out of exhaustion, the exhaustion of a system that extended its hand and watched it get pushed away one more time. If you have seen a case where someone blamed everyone around them and the court finally said enough, drop it in the comments below. And if there is a specific courtroom case or legal confrontation you want us to break down next, tell us. We read every comment. Subscribe and share this video. An informed public is the only real check on a system that too often operates in the dark.